Over the years, people have tried some very off-the-wall arguments in the courts to try to get rid of their criminal cases. I'm referring, of course, to people who represent themselves. Many of them are very well self-educated. I would never recommend, I certainly would never represent myself in court without the assistance of counsel. I'm not sure that most people would, but there are some who do and might even pull it off effectively. However, trying to enlist sovereign citizenship and sovereign immunity and tax protester arguments won't get you anywhere. I have seen it. It's an embarrassing thing to witness. I've seen guys in custody who flatly refuse any sort of court-appointed counsel, and I understand that sentiment. I mean, that's why private attorneys like myself exist, because there is a demand for private attorneys. I get that. That's not what I'm referring to. I'm referring to people who stubbornly cling on to sort of fringe beliefs having to do with the government not having any jurisdiction over them, not having any right to hold them in court or hold them in custody or anything like that. Now, there are obviously good legal arguments that you can use to address those points. That's not what I'm referring to. I'm talking about very fringe stuff like the judge not having the right to preside over the case for something that doesn't even have anything to do with the law. They'll pick some bizarre technicality like the flag pointing the wrong direction, or the eagle pendant on top of the flagpole facing an incorrect direction. I mean, just some off-the-wall stuff. You're wasting your time. You're wasting your own time, and you're wasting a valuable opportunity to make some actual legitimate points. Let's talk about the stuff that does work. If you're going to represent yourself, it's something I wouldn't advise, but if you're going to do that, study how the process works. Study what happens at an arraignment, the first court appearance, which really sets the stage. If you're going to make arguments, now you're limited in the arguments you can make, because really you're there to enter a plea of not guilty or guilty if you plan on submitting yourself to the case. But there are legitimate arguments you can make regarding your bail situation. If the court wants to impose bail, you can argue you're not a flight risk, and you can show why that is. Throughout the case, you can hire a private investigator to help uncover maybe the witness is not telling the truth, or has made specious allegations against people in the past, or you're able to get footage of yourself that proves up your alibi when in fact the police are trying to place you at a particular point in time and at a location at the crime scene. That stuff is going to get you a lot farther. Now, that's the tip of the iceberg. It takes a tremendous amount of expertise and skill and all that to really, really, truly fight these cases. If you're going to do it yourself, don't make the foolish mistake of listening to those who champion fringe sovereign citizenship type arguments. I'm not making any sort of a political condemnation. It's the furthest thing from that. I'm talking about specifically whether it's effective in the courts. It is not effective in the courts at all. Okay? What you want to focus on is the prosecutor's evidence in the case. For example, you can make constitutional arguments. I'm not saying that they don't work. For example, if the prosecutor wants to use a police or a statement that was recovered by the police as to something you said, you can challenge it. Were you in custody at the time? And if so, did he read you your rights before he started asking you incriminating questions? That sort of thing is effective. You can file what's called a motion in limine. In California, I believe it's section 402 of the Evidence Code. You can have that excluded from being heard by a jury at trial if it's a damning statement they'll never hear it if the court approves it. That's something that can work, and that doesn't work all the time, but works a hell of a lot better than non-legal arguments. Another thing that might work is if, let's say, I see this mostly in drug cases. If it's a drug case and the police seize your property without a warrant, and they enter your home without a warrant, without first having probable cause, you can file a motion to suppress under Penal Code Section 1538.5 here in California. You can file a motion to dismiss the complaint, Penal Code Section, I believe it's 997. There are so many great ways of challenging the prosecutor's case, focusing on the admissibility of a lot of this evidence, because if it's unconstitutional for the police to have gotten in the first place, then you can make these sort of grandiose constitutional arguments. Sadly, a lot of these fringe sovereign immunity type folks just don't have a clue as to how the legal system works. You have to understand, I mean, there are lots of things about the criminal justice system I don't like, you don't like, a lot of people don't. And you can have those arguments all day long, but at the end of the day, you have to ask yourself, do you want to win or do you want to lose? Because if you want to win, you're going to have to put all that stuff aside. And it's interesting, and you can go into a whole, rabbit hole on the internet as far as that is concerned. Knock yourself out. But if you want to free yourself from the shackles of imprisonment and conviction, don't follow that stuff. Stay grounded in the law. And you apply that to the facts of your case. You may be successful on your own, and or with the assistance of somebody like myself, a very experienced criminal defense counsel or somebody of that caliber in your area. Thanks.